Thank you, Tony, and it's certainly it's a pleasure to be here and to be here for the Ohio Lakefront Group. I attended many of their meetings. This does affect my district. And I guess the question to be asked is what is more important than a basic right of property ownership? I mean, that is really what we're talking about here. Governor Strickland ordered the ODNR to stop enforcing policy that required property owners to lease their own property, but yet constituents have collection letters demanding lease fees for private property. And for that reason, I am standing here today to call on ODNR to immediately begin following the governor's policy and stop sending letters to Ohioans demanding money for private property. Intimidating our residents who are law-abiding taxpayers is not right. The governor and ODNR need to talk and stop this practice. My message is simple. That's what I wanted to say here today with the Ohio Lakefront Group. Thank you for that opportunity to express it.
A Lakefront representative, Tom Peck.
Thank you. Good morning, folks, and I'll be very brief. First of all, I wholeheartedly agree with my state representative, Dan Baker, as well as the eminent Bill Seitz, who is always a tough act to follow. I have seen the intimidating letters that my constituents, our constituents, Dan and I have received. They're unconscionable. I'm a firm believer in the law. I've been raised by a father who was a longtime Cleveland policeman. Many of you have heard me talk about that. My older brother was a homicide detective. I've got a handful of nephews, policemen, and the only son that I have with a family of 6 children has also been 9 years a policeman. I just believe in the law, and I wish that the folks at ODNR would simply follow the law. I'm alarmed at why they've chosen to go against these folks at ODNR with the governor's policy. It was very basic, it was simple. He promised it during his campaign, and he also reiterated it once he was in office. But yet these intimidating letters continue to go forward. So we, again, while Senator Seitz was confused why they had they stood down in previous court rulings, and now they're back again. I'm not sure what has driven them to do this. I just can't understand. And I think that you talk about 15,000 or so lakefront property owners, but I think that the message that Tony mentioned really is what needs to be listened to by the people of Ohio. Today they're going after lakefront property land, and then tomorrow they're going to go after some of the inland, lakes and streams. Where to does it stop? So we need to make them stop now. I do publicly call on the Ohio Department of Natural Resources to immediately stop sending letters to all Ohioans, especially my constituents, demanding lease payments for their own private property. Further, I call on the Department of Natural Resources to implement rules that are consistent with Governor Ted Strickland's policies. Thank you very much.
People who don't know, on the east side of Cleveland, we have another good senator, Senator Tim Grendell, who's been a champion for our issue for a long time, and also a property rights attorney.
Good morning, and thank you for coming out. First of all, protecting private property rights ought to be a bipartisan issue. And that's why I applauded Governor Strickland when he kept his campaign promise and undid the damage of the prior governor and recognized the private property rights of the lakefront property owners. I would like to dispel a couple of falsehoods that keep surfacing on this issue. First of all, this isn't about reducing access to water. This is about protecting private property rights. The citizens of Ohio have extensive access to the Lake Erie shoreline. There's approximately 300 miles of Lake Erie shoreline, and there are 312 boat access sites along that 300 miles, which is approximately 1 per mile. There's 152 public boat ramps that allow you access to Lake Erie, and there's 116 parks and public recreation areas to provide the 11 million citizens of Ohio ample access to the lake. Now, there's a reason why there's 116 publicly paid for parks and public recreation areas, because up until 10 years ago, everybody recognized that you had a deed that said you own to the water's edge, you own to the water's edge, and the public didn't have a right to walk through your backyard on Lake Erie any more than anybody else's backyard anywhere else in the state. And that's why there's 116 places paid for with public money to give the public access to and recreation along Lake Erie shores. This issue is about property rights, and Senator Seitz said it so eloquently. There's been a bureaucratic oppression to take away the private property rights of those folks who have been fortunate enough to buy property along Lake Erie. Governor Strickland said he'd recognize those deeds. He indeed was a man of his word and recognized those deeds. Now let's fast forward. At the time the governor did that, he told Attorney General Dan, I now am going to recognize those deeds. Attorney General Dan decided he was going to represent somebody, we're not sure who, because it wasn't ODNR anymore, and it wasn't the governor of the state of Ohio, because the state of Ohio was represented by the governor. And in fact, the governor had to go out and hire a private lawyer at the taxpayer's expense to represent the governor's position in the litigation. And the governor and ODNR decided that they apparently were satisfied with Judge Lucci's decision at the common police court level because they didn't appeal it. Now, they didn't appeal it. The matter goes to the 11th District Court of Appeals with Attorney General Dan representing somebody. Oddly enough, from an ethics viewpoint, I'm still trying to figure out who he represented. He didn't have a client, and if he did claim to represent the people of Ohio, he was representing them against his former client, ODNR and the governor. And last I looked, that was unethical. I can't switch parties in the middle of a suit and represent somebody's interest against that of my former client. But that's something the Attorney General has done, and I've still not figured out how the following Attorney Generals have continued down that unethical path. But we've got a rogue Attorney General representing somebody, and the thing comes down to the Supreme Court. Suddenly, ODNR and the governor are back in the suit. I asked Kent Marcus, the governor's very capable counsel, how does a party who doesn't appeal get to come back in the suit later at the Supreme Court? And he said, Senator, that's a good question. And it's a question I hope the Supreme Court answers by dismissing the governor and ODNR from the Supreme Court suit, because they got no right to be there since they didn't participate in the appeal. I might add something to this Attorney General's issue, since they're going rogue on us anyhow. There's a misunderstanding that's been proliferated in the media about something that happened in the Court of Appeals in this. The media reports that the issue of the Attorney General's right to continue to represent somebody in the suit was never raised in the Court of Appeals. And that statement is flat out false. Homer Taft is one of the parties in the suit, and if you look at his appellate brief, he specifically raised the issue of the Attorney General's lack of standing to be in the suit. Now, the Attorney General filed a response brief to Mr. Taft's brief in which they argued the issue of the Attorney General's right to be in the suit. And the first question asked at the oral argument in the Court of Appeals of the Attorney General's lawyer who was arguing was, how does the Attorney General have a right to be in this suit? Unfortunately, Judge Cannon, in the concurring opinion, misstated that the issue was never raised in the Court of Appeals when it clearly had been briefed by Mr. Taft, briefed by the Attorney General, and argued by the Attorney General in front of the Court of Appeals. But we don't have just a rogue Attorney General, we now have a rogue Department of Natural Resources. The governor says we're going to recognize their deeds, and the Department of Natural Resources is still sending done letters out to lakefront property owners telling them they have to rent their property back. That is not consistent. The Department of Natural Resources resurfaced in the litigation. That is not consistent. And unfortunately, even the governor now has risen again in the litigation, and that is not consistent with the governor's prior position. All I ask is that Governor Strickland honor his commitment to the lakefront property owners, that they own what they own in their deeds to the water's edge. And I ask that there's something wrong here. And the question is ODNR gone off the reservation and gone rogue without the knowledge of the governor? And if that's true, I call upon the governor to rein in the Department of Natural Resources, to quit sending those letters and to honor those deeds. Or has the Governor Strickland, as he has with gambling and the 4.2% tax increase, suddenly flip-flopped his position? If he has, I ask that he flop back to the right position, which is recognizing the private property rights of lakefront property owners. Thank you.
Somewhere else. Property rights are an inalienable right. That is one part I understand of the Constitution. It is clear, and I represent the largest inland lake in Ohio, which is Grand Lake St. Mary's, and Fort Laramie Lake are both in my district. And those people that spoke before me are on the front lines. It's their battle that has to be won, because if they can win it there, and we continue to have ODNR and the Attorney General taking fees twice on property owners, we're next. So therefore, I support them, and this is something that needs to be reversed, and I agree with all those that spoke before me. Thank you very much.